everybody, and you're very welcome along to the next episode of our Keep It Simple series in Season 4, all about property. So today I just want to touch you brief on the difference between the ordinary power of attorney and the enduring power of attorney. Now, we face this quite often here in the office when an older family member may have to go into a home and they can no longer look after the financial needs. So in this case, people will ask me, God, what do we do? What's the difference between the ordinary power of attorney and the enduring power of attorney? So it's actually crucial in understanding the difference for making the right decision. So basically, the ordinary power of attorney is it's actually a legal document that allows the individual called the donor to actually grant another person, the attorney, the authority to act on their behalf, to look after their, their financial and their legal needs. So the ordinary power of attorney has specific, powers to manage a person's affairs, such as selling the property. However, it's only valid while the donor still has his or her mental capacity. That's a really important point to note. And this type of power of attorney, therefore, just literally is for temporary. It's a temporary measure or for short-term situations, and it does not require registration with the court. Now, the enduring power of attorney, on the other hand, is very, very different. And it's designed to continue even if the donor loses his or her mental capacity. So, and because of this far-reaching, you'd call them extensive powers, there's a lot more legal controls. So the solicitor has to ensure that the donor is not under any undue pressure. There's no fraud involved. And the enduring power of attorney can only take effect once it's actually registered with the High Court, where you don't have to do that with the ordinary power of attorney. Relatives also have to be informed. Just remember that. And when it's created, once it takes effect, it has to be, it's actually, the attorney can only retire with the court's consent, and also the enduring power of attorney can only be revoked with a court order. So choosing the right option is just so important. As we're saying, if the donor still has his or her mental capacity, then it only requires temporary assistance, and the ordinary power of attorney will be sufficient. However, if on the other hand, if long-term planning is needed, let's say where the person is completely mentally incapacitated, then the enduring power of attorney will provide that necessary legal security for you. So I hope you found this helpful. And if you have any questions or comments, please just put them there in the chat box. Thanks for listening.